Friends, after the discussions that we have had so far, especially on non-governmental organizations and on cooperatives, I think the Supreme Court laid down to rest all such doubts about these organizations and their ability to be brought within the purview of the Right to Information Act. In this judgment of 2013, Talpalam Service Cooperative Bank versus the state of Kerala, a matter that came before the Supreme Court of India, the Supreme Court did clarify the challenges that remain, especially on looking at organizations that are supposed to be brought within the purview of the Right to Information Act or not. Now, if you look at this case, the case arises from an application that was made to a rural cooperative society in Kerala. The name of this cooperative society is Malur Rural Cooperative Society, and the RTI applicant wanted certain information relating to bank accounts of certain members in this rural cooperative society bank. Interestingly, bank account details of members of a cooperative are generally held in fiduciary capacity, and hence the society refused to grant access to the said information, saying that it is confidential in nature, and the providing of the said information would violate commercial confidence of the members, and hence such information shall not be handed over. Interestingly, providing such information has no relation to any public activity carried on by the society. So the activities of the society and giving of the said information was not having any relevance to a public activity is what was the defense that was taken in this case, and the information was not provided. However, the matter went to the State Information Commission, and the State Information Commission had to look into the circular issued by the Registrar of Cooperative Societies, in which it had very clearly established that the registrar, this is the Registrar of Cooperative Societies in every state, had stated that the Registrar of Cooperative Society has administrative control on all such societies as public authority falling within Section 2H. So this circular was kind of misleading, because when the circular was issued, the Registrar of Cooperative Society definitely has the power to issue such circular, whereas it stated that he or she can exercise that administrative control, but it also implied that all these private cooperative societies who are accountable to the Registrar of Cooperative Societies will be deemed to be public authorities, right? So this was something that was kind of a problematic situation. The cooperative society challenged this decision, and they filed a writ petition in the High Court of Kerala challenging the order of the State Information Commission, and the single judge of the Kerala High Court declared that all cooperative societies registered under the Societies Act were public authorities, and they were bound to disclose the information under the Right to Information Act. So this was kind of a decision that was provided for. From there, an appeal comes to the Supreme Court with two substantial questions to be answered. First, whether the cooperative societies fall within the definition of public authority under Section 2H of the Right to Information Act, and if a cooperative society is bound to provide such information to a citizen. So if the first question is in affirmative, the second is also. Now, interestingly, the Supreme Court in this case, as usual, goes into the definition of state under Article 12 of the Constitution of India, and the court refers to previous cases and concludes that the level of direct or indirect control with respect to societies does not meet the required threshold of what under Article 12 is called the deep and all pervasive test, right? So under Article 12, if an agency has to be declared as a state or its instrumentalities, the control of the government must be deep and all pervasive. Now, unfortunately, in the case of cooperatives, that fails, right? The court went on to consider further whether RTI is applicable if not the application of Article 12, right? So if one assumes the essential parts of the provision as applicable in this case, which is about what we call as substantial funding, right? So the deep and all pervasive control is something that is applicable to the control test. However, if an NGO fits within to the substantial funding test, then additionally under the Right to Information Act, though not a state under Article 12, under Right to Information Act, they can be brought to a sense of accountability, isn't it? So RTI Act is Article 12 plus something else. And what is that plus something else? It is NGOs or non-governmental organizations that do not have any control from the government, that are not owned by the government, but if substantially funded, are covered under the Right to Information Act. So hence, in terms of the accountability on the RTI Act, the scope of Section 2H, according to me, is far wider than the scope that is brought within Article 12 of the Constitution of India. Right? The court did look at the definition of the term substantially financed, and you will notice that there is no such definition of substantial finance. And please note, substantial finance may be direct or indirect, right? But when we look at the term substantial finance, whether direct or indirect, the Supreme Court said, and very importantly, that the finance must be actual, existing, positive and real. Very interesting. This is what the Supreme Court means. That it should not be illusory in nature. It should not be something that is just so meager that it fails the purpose of the legislature. The word substantial clearly means something very, very prominent, right? And it is so actual that it adds value to the functioning of the non-governmental organization. And hence, in this case, if I were to add to the understanding of the judgment of the Supreme Court in this Thalpalam Service Cooperative Bank case, then I would say that when the substantial finance into a non-governmental organization test is to be applicable, it is not a project grant. It should not be just merely a project grant. It should be a grant that goes to the capital of the non-governmental organization. So it must be something actual. It must be existing. It is positive and it should be real to a substantial extent and not moderate, ordinary or tolerable. Now, I think this sentence of the Supreme Court, now I should repeat this sentence because I think the test laid down in this case of 2013 is a test as a precedent law, because what the Supreme Court says is the law of the land, should be made applicable to all such organizations in the future. I repeat, the finance under the Right to Information Act as applicable under Section 2A must be actual, existing, positive and real to a substantial extent, not moderate, ordinary and tolerable. The court also noted that the state may provide schemes for welfare projects, but unless the funding was so substantial, the body would struggle to exist without that, right? So the relevant provisions could not be engaged. Thus, the court said merely providing subsidies, grants, exemptions and privilege does not qualify the requirement of substantial finance. And hence the court said schools getting 95% grant in aid from the government would be an example of substantial financing. This is the interesting example given by the Supreme Court in this particular case. As for NGOs are concerned, the court stated that even in the absence of statutory control, it is possible to establish that an NGO has been substantially financed directly or indirectly by government funding. The matter would bring those organizations within the definition of public authority. And hence the court ruled that the onus of proof to show that a body is owned, controlled or substantially financed, or that an NGO is substantially financed directly or indirectly by the funds by the appropriate government, is on the applicant who seeks the information, or is on the appropriate government, right, as the case may be, right? So unless they prove that it is substantially financed, organization need not accept it to be brought as a public authority within the definition of Section 2H. The court engaged in balancing the disclosure of information and privacy rights, and it concluded that the information in this case is personal and does not relate to any public activity or interest, and the public authority or the officer is not obligated to comply with the said request, because he was asking about bank account details of the members of the cooperative, which is definitely confidential information without any public interest that is proved. This same need not be disclosed under the Right to Information Act. And hence, in this case, the Service Cooperative Bank, the Thalpalam Service Cooperative Bank, was held not to be a public authority by the Supreme Court because it did not fulfill the substantial finance test. Now, I have to repeat this because it's a Supreme Court judgment. Kindly note, there are a couple of things that are the learning curve that we must take from this case. First, that to come within the definition of substantial finance, the finance to the NGO must be actual, existing, positive, and real, right? To a substantial extent, right? Second, such kind of finance should be such that the body should struggle to exist without it, right? So it must be so important and relevant. Like I told you, more than a project finance, it must be some kind of a capital finance. Thus, please note, merely granting subsidiary grants, exemptions, and privileges, or if the finance is moderate, ordinary, and tolerable, in those cases, unfortunately, the non-governmental organization cannot be held to be a public authority in any matter. So I think the judgment of the Supreme Court now is very clear about what tests to be applied in case of non-governmental organizations, and how should the matter be perused by information commissions before they can declare any kind of cooperative, any kind of society, any kind of non-governmental organization within the definition of the right to information.